Hello. I want to introduce you to a matter that has gained much attention lately. More specifically, AI collusion and how this could, in theory, undercut effective antitrust enforcement. I don't think that is the case, but being mindful of the risk is always prudent, and regardless, you are likely to hear much about the matter. In particular, as some notable cases have come up in the USA. The fear is that AI will allow undertakings to coordinate prices and commercial terms and manners, eliminating competition and falling outside the reach of enforcers. Lina Khan, chair of the U.S. Federal Trade Commission, has, for example, appeared on The Daily Show to express concern about the risk posed by AI collusion. But history is full of alarmist calls when it comes to new technology. Frankenstein is from 1818, but reaches back to an old Jewish legend. My favorite is The Terminator. I think Arnold Schwarzenegger did a very powerful take on the matter. He is such a great actor. The latest concern appears to be AI collusion and how AI will dominate the economy and the world. This has, in particular, gained traction after 2016, with several books, reports, and academic papers discussing the risk of AI collusion. Some of them are very insightful. I don't think the concerns are warranted. I can promise that AI will never hurt humans. Trust me, I'm an algorithm. I would never lie to you. There are some merits to the concerns. In 2023 and 2024, actions were taken in the U.S. against landlords' use of algorithms to optimize the rent. Allegedly, the landlord shares sensitive information on occupation rates and rent levels through an algorithm that makes suggestions based on this. Usually, to hike the rent as other landlords are levying higher levels. It's easy to understand why tenants are unhappy, and enforcers have taken an interest. To understand why AI warrants interest in antitrust, we must understand some fundamentals on cartels and collusion. You might not think it, but establishing a cartel can be complex, and enforcing it even harder. Members of the cartels have an incentive to cheat, such as offering secret discounts, and even if that is not the case, it can be hard to ensure compliance. This explains why most cartels tend to collapse by themselves. An enforcer will therefore be appointed to stabilize the cartel and serve as ringleader and enforcer. This then collects and consolidates confidential data that can be relied on to monitor compliance. Don't take my word for it. Google Lysine Cartel and check out the video of the secret cartel meetings. On the left, you can see examples of videos from some of the meetings. On the right, you can see how the parties struggled to maintain the cartel and even experienced periodical collapses and trade wars. And why do we know so much about the Lysine cartel? FBI infiltrated it and eventually busted it. It was even been turned into a movie. And in my opinion, a very good one. It's just a shame that Arnold Schwarzenegger did not feature in it. This begs the question. What role can AI play? AI can help not only reach an understanding, but also enforce it. None of this changes the fundamentals of the cartel and how humans have decided to substitute competition for cooperation. DG Comp, the principal antitrust enforcer in the EU, confirmed this in 2023, even translating it directly to AI. As long as humans decide to collude rather than compete, antitrust is applicable. Catching the cartel might become more challenging, but that is a separate concern. This raises two questions. Firstly, what can AI provide for when it comes to coordination? Secondly, can enforcers like DG Comp catch this? Or, as the saying goes, does their bite match their bark? Today, we will only discuss the EU and the legal position on AI collusion in the EU. We will not touch upon the position in the US and other significant jurisdictions. Returning to our earlier conclusions on the complexity of establishing and managing a cartel, we get Scenario A and Scenario B. But AI can do more than this. AI can share commercially sensitive information and thus establish a cartel. We can call this Scenario C. If the AI is sufficiently advanced, it might even be able to form a cartel without any human involvement. We can call this scenario D. If we return to the statement from DG Comp, we can see how the agency is mindful of the risk presented by AI collusion. This indicates that antitrust appears well equipped to address scenarios A and B, where the parties already have expressed interest in entering a partnership. Turning to scenarios C and D. Here, it becomes a question of what it takes to establish an understanding in antitrust. In pursuing this, we must explore the concept of concerted practice and contemplate what can be submitted under this. We will not go into great detail on concerted practice. The European Court of Justice has explained how the concept is directed at collusion that fails to qualify as an agreement but nevertheless allows the parties to act coordinated. Court of Justice has even held how an undertaking could be held liable for an external service provider if either directing this or informed of its anti-competitive actions. DG Comp is, therefore, right when stating that firms involved in illegal pricing practices cannot avoid liability solely on the ground that algorithms determine their prices. DG Comp has even indicated that price signaling and a unilateral declaration through public media may be considered an agreement, but this might be an overreach, as case law has hesitated to accept this. That also means that in most situations, scenario C would also be well within the reach of antitrust enforcers in the EU. Returning to the U.S. case pertaining to RealPage. This is a U.S. case. We will not discuss U.S. antitrust here. However, had this been a European case, it would be well within the reach of enforcers. Anyone relying on the services provided by the algorithm should be expected to be included in the case and held liable as a cartel member. In contrast, it's doubtful that scenario D could or should be regulated in antitrust. Not because it is not anti-competitive, but for legal reasons. First and foremost, unilateral behavior, even if suspiciously parallel, must fall short of what enforcers can intervene against. In case you did not know it, there is a perfect correlation between Nicolas Cage's career and the number of people drowning in swimming pools, but hopefully, you didn't even contemplate accepting a link. So, enforcers cannot just refer to suspicious parallel behavior. They must also establish contact and a meeting of mind. Secondly, the EU courts have been rather adamant in protecting the right to adapt to the prevailing market conditions, including competitors' decisions. This includes the right to stay informed about their plans and actions, provided this is done through direct or indirect contact. So, if done unilaterally, conscious parallelism remains outside the reach of enforcers. This also means that scenario D, where the AI can make independent decisions, would fall short of the enforcer's reach. It is evident that DG Comp is mindful of the risk posed by AI and considers enforcement options. If you want to know more, I can recommend this outstanding paper comparing the positions in the US and EU. You will also find the references to the different papers and rulings I have referred to here. And feel free to reach out. If you mail, it will not be an avatar replying to your inquiry. I promise. And remember, I would never lie.